Chapter 8 is talking about evidence that includes documents, models, maps, and diagrams. So let's start with documents. Documents includes a wide range of items. Could be anything from words, letters, numbers, pictures, and even sound. So one thing we have to do when we submit a document as evidence is authenticate it. And this is proof that a document is what it claims to be. Under Federal Rule of Evidence 901, this controls the methods and conditions of authentication. Generally, meeting 901 is a precedent to admission, and it gives 10 illustrations within the rule itself that would kind of shed a little bit more light on this topic. So what are some of the ways we can authenticate something? Well, we can do this with testimony of a witness who has knowledge of the document, a non-expert opinion on handwriting. We could look at distinctive characteristics of the document. We might look at voice identification, telephone conversations as well. Another thing that often gets brought up into evidence is ancient documents. And we'll talk about this a little later in the chapter, but these are usually items that are 20 or 30 years old. And that's based on their condition, location, and age determines whether or not they're in an ancient document. And then the law or statute is going, either the rules of evidence or statute is going to dictate the method by which these items will be authenticated. So some documents carry a presumption of admissibility and they're considered self-authenticating. So public documents under seal, certified copies of public records. So you might go to City Hall to get a certified copy of your birth certificate, newspapers or periodicals. Other items that might be self-authenticating, acknowledged documents, commercial paper. There's some presumptions under acts of Congress, etc., etc. So common self-authenticated documents include sealed government documents. So these are documents created by local government, state, or federal government. They're sealed, and if they've been certified by the government, then they're self-authenticating. So again, if you've ever had to get a passport, you usually have to get a copy of your birth certificate, and you need a certified copy with the seal on it. They don't want a photocopy of it. They want an original copy. You might also have a document that's been notarized. If you've ever filled out a medical power of attorney or signed a medical power of attorney for somebody, that's a document that gets notarized. So a notary public witnesses the document. They take your ID, they write it in a book, they put a fancy little stamp on it. So there's often an attached record of acknowledgement that this is an impartial third-party witness to whomever assigned the document. So official publications from the government, so things like the criminal law or the criminal code, if somebody presents that in court, that's considered authenticated. If a witness has direct knowledge of something, their testimony, and someone who's familiar with the handwriting, like you would recognize, your significant other, or if you are married, you would maybe recognize your spouse's handwriting, and you'd be able to kind of give a lay opinion on that. Okay, we also might use a forensic document examiner. So someone who is a handwriting expert who could take a sample of handwriting from the person in question and then compare it to a written document and determine whether or not there's enough distinctive characteristics that would allow them to say, yes, this is the person who has written this document. You might also look at distinctive characteristics, something that's unique about the document. And again, things that are public records. So these are often reports. As I mentioned before, an ancient document is usually about 20 years of age. There might also be a proof that's made in the production of a document, so like an X-ray. That would be self-authenticating as well. So what can a forensic document examiner do? They can testify either this document is authentic or they might testify that it is not authentic. And they could do this based on handwriting or signature, typewriter, printer, or fax, check machine, stamp or label, the printing process, and even the ink. And so manufacturers put chemicals in their ink from year to year that allows you to tell what year this particular ink was manufactured. So these things we might look at. Handwriting composition. What's really going to matter here is the skill of the examiner. Okay, so the examiner is really going to be looking at a sample that you would be asked to provide and then comparing that to the original document. They might look at things that allow them to determine the make and model of either a typewriter. This is a little bit more difficult to do with a printer. They look for any alterations or erasures that have been made, any evidence that could be changed, any evidence that there's been a change made to the document. And as I mentioned, the Bureau of Alcohol, Tobacco, and Firearms has a library of ink that they compare samples to, so they can determine when and where ink or when and where paper was made. So all statements made out of court, including documents, are considered hearsay. And generally, hearsay is not admissible in court. Okay? There's two big exceptions to this in regards to documents. One is business records, and the other is official documents. There's quite a few, not examples, exceptions to the hearsay rule, and we'll talk about that in a later chapter. So business records, these are records that a business keeps commonly. So if you owned a gun store, records of purchases, telephone records of calls made, any time cards that are stamped for the hours that your employee works. So these are records that are routinely kept. And so these are not considered hearsay and they're admissible in court. There's three basic requirements in order for them to be allowed into court as an exception to the hearsay rule. So they have to be based on someone with knowledge of the event recorded. The record has to be made in a timely manner and in the regular course of business. So again, think about a time card. The last job I probably worked where I had a time card is when I worked at CVS, and we punched into a computer, punched in with an employee number, and it automatically recorded the time you punched in. And then you clocked out as well. And the record has to be something that's commonly or regularly made by that business. Public records, so this is the official records hearsay exemption, generally covers any report or record made by a government agency in the ordinary course of their work. So again, things that are regularly or routinely kept as part of their job. That would include factual findings by the government and mandatory reports. Now, investigative reports are not covered, and those are still considered hearsay. So how do we introduce this content, the content that's within a document, into evidence? Well, first we follow what's called the best evidence rule. So whenever possible, we want to admit the original document as opposed to a duplicate. And Federal Rule of Evidence 1001 defines terminology for us. Writings refers to words or letters. Photographs refers to photos, x-rays, film, and video. Original means the writing or the photo itself, and a duplicate is a counterpart produced from the original. So a photocopy, for example, or some type of duplicate. FRE 1002 requires the original to prove the content of the document. And FRE 1003 says that duplicates are admissible. It can be admissible, but it's unfair to admit it in place of the original record. FRE 1005 says we can't admit copies of public records. So let's talk about this primary and secondary evidence. Primary refers again to that original document. This poses a problem for us with things like computer records, and think about most of the records that people probably keep today are electronic in nature. Even your medical records tend to be electronic. Primary evidence can be used to establish the content. Secondary evidence is evidence behind or beyond the original. So that would be a copy. Parole evidence is evidence introduced as to what is in a document or what was supposed to be in the document. Secondary evidence. What do we do if the original has been lost or destroyed? So what if your birth certificate was in a building where there had been a fire? So FRE 1004 governs when the original is lost or destroyed, if for some reason it cannot be obtained, if it's in the possession of the opponent, or if it relates to a collateral matter, so something not closely related to the case. So this would include things like things that we could use here that are examples of parole or secondary evidence, a first draft of something, dictation notes, copies from ledgers. Photographic evidence is also frequently introduced into court. And so in order to be admissible, it has to be relevant. It has to accurately depict the scene, and primary photos are always going to be preferred over secondary photos. And finally, as we talked about in a prior chapter, it should not be unduly prejudicial. Again, we need to lay a proper foundation. and this refers to all types of photographic media, so photos, videos, etc. Models, maps, and diagrams, there's a lot of judicial discretion here as to whether or not it's admitted. But the most important piece generally is how accurate it is, with the idea that it should be drawn to scale. So a lot of times computer simulations are more common, and this is used as a demonstration, but it still needs to meet all requirements of other models. So remember, we looked at in a prior chapter, maybe the one right before this, there was a drawing of a crime scene, and we want to make sure it's drawn to scale. So with computer models, the advance of computer modeling, it's possible now to make these very sophisticated 3D dimensional models as well. And this is just going to raise some other issues. And that wraps up this chapter.